Let's talk about California's state tax controversy and litigation process. How does the FTB, the CDTFA, the EDD really work? What happens when you challenge a California tax audit or an assessment? If you're fighting a tax problem in California, whether with the Franchise Tax Board, the California Department of Tax and Fee Administration, or the EDD, you're dealing with some of the most aggressive state tax agencies in the country. And here's the truth most taxpayers never hear. Once California issues a tax assessment, the burden is on you to prove the agency is wrong. If you miss a deadline, you file a wrong appeal, or you say the wrong thing during a protest, you can lose your rights almost instantly, and the state will move directly to enforce collection action. Before you respond to anything, you need to understand how California's tax controversy and litigation systems actually work and how to defend yourself inside of these systems. Hi, I'm David W. Klasing. I'm a dual licensed tax attorney and CPA, and for nearly 30 years, I've represented taxpayers statewide in audits, protests, appeals, administrative hearings against the FTB, the CDTFA, and the EDD. Listen, California's tax system is unique, and understanding its structure is the key to winning your case before penalties, levies, or criminal tax exposure escalate. Let's talk about why California tax agencies are different from the rest of the country. California tax agencies operate independently from the IRS, but they share information aggressively amongst themselves and with the IRS. The FTB handles income tax. The CDTFA, they handle sales and use tax, excise taxes, fuel, cannabis, and other excise taxes. The EDD enforces payroll and employment tax. Each California agency issues its own audits, their own assessments, their own deadlines, and they have their own appeals process. Most importantly, California agencies assume they're correct from the get-go. You must prove otherwise. And if you don't dispute their findings properly, their determinations become legally binding. Your case usually begins with an audit notice or a proposed assessment, like the following: an NPA, Notice of Proposed Assessment from the FTB, a Notice of Determination from the CDTFA or EDD, an Employment Tax Assessment from the EDD. From here, California begins calculating tax, penalties, and interest, often reaching back 3 to 8 years if you disagree with their findings. You must file a protest within strict deadlines. Miss them, and the state finalizes the assessment automatically. A well-written protest is your best opportunity to challenge audit errors, misapplied California law, incorrect residency findings, apportionment errors, erroneous nexus determinations, fighting estimated assessments, fighting penalties for negligence or fraud. The appeal stage is crucial. Poorly written protests or emotional explanations could lock you into a position you can't undo later. A strong protest includes a clear statement of each issue you disagree with, supporting documentation, legal arguments under California tax law, a request for an informal hearing. Handled correctly, many cases end here. If the protest doesn't resolve your case, you move into California's informal appeals process. This step varies by agents. With the FTB, you get a protest hearing with an FTB hearing officer. With the CDTFA, an administrative review and appeals conference. With the EDD, the petition process and hearing process. While this stage is called informal, your statements, documents, and testimony can be used against you later. California evaluates whether the auditor applied the law correctly, whether your records support your claims, whether any penalties assessed during the audit should remain, whether residency and sourcing findings hold up, whether inconsistencies suggest willfulness or fraud. A well-prepared file can overturn the audit in its entirety. If you disagree with an agency's appeals decision, your next step is the Office of Tax Appeals, the OTA. This is California's independent tax tribunal. At the OTA, your case becomes more formal. It's going to require written briefs, legal arguments, evidence packages, and you'll eventually get a hearing before an administrative law judge panel. OTA decisions are binding and can only be challenged by petitioning California Superior Court. You must also pay the tax that's at issue. Most taxpayers should not represent themselves at this stage. California tax law is complex, and OTA judges expect clear legal authority. If you lose at the OTA, you may file a lawsuit in California Superior Court to challenge an illegal or improper tax assessment. Litigation at this level requires complying with strict procedural rules, filing a claim for refund, providing detailed legal briefs, going through discovery, depositions, and hearings, and a potential trial. This is a long and expensive route, but sometimes it's the only way to correct major errors in California's findings. Listen, you shouldn't attempt to handle California tax disputes alone. California tax agencies are among the most aggressive in the country. You shouldn't handle your case alone if you own a business, you've been hit with sales tax, payroll tax, or other use tax, the state's claiming you're a California resident when you disagree, you operate in multiple states and California is overreaching, you have missing records, or the state hints at penalties for willfulness, fraud, or evasion. You received an estimated assessment, your case is headed to OTA or beyond. Most taxpayers unintentionally make their case worse by submitting unnecessary documents, over-explaining, contradicting themselves, or missing key legal arguments. Here's what a tax attorney CPA combo person like myself can do for you. We can reconstruct records. We can build a legally sound protest. We can identify errors that were made in the audit. We can challenge incorrect residency findings. We can correct apportionment or sourcing issues. We can prepare appeals conference files. We can represent you at the OTA. We can litigate in California Superior Court. And all the while, we protect your communications with attorney-client privilege. And we coordinate privileged accounting under a Covell agreement. California tax controversies require a combination of legal, strategy, accounting skill, and experience with the state's unique procedures. A combination of legal strategy, accounting skill, and experience with the state's unique procedures. If you're facing an audit in California, an assessment, a protest, an appeal, or a collection action from the FTB, the CDTFA, or the EDD, don't wait and don't go through it alone. California's tax system is complex, and one mistake can make the situation significantly worse. Call the tax law offices of David W. Klasing at 800-681-1295 or visit KlasingAssociates.com to schedule a confidential reduced-rate initial consultation today. We'll defend your rights, we'll protect your business, and we'll guide you through every step of California's tax controversy and litigation system. Thank you.